Good morning, everybody. So nice to see so many of you here, both online and also physically. This is a great opportunity for me to introduce someone that I think is going to be doing interesting things in the future, and that is Andreas Hösli. Andreas is doing his PhD, about to finish at the University of Zurich, but he's also very interested in working and collaborating very actively in Scandinavia. And his topic is climate change, litigation, and connections also to matters of private liability. And Andreas is a PhD candidate, as I mentioned already, in the University of Zurich. He's doing a research stay at the University of Oslo, where he is working with some of our colleagues that we know quite well. Beate Schofield is one of your supervisors. And Andreas and I, we met about a year ago in Copenhagen. No, it was this year. Yeah, it was in February this year, where I was talking about how to decommission oil and gas rigs, and he was telling me, oh, I'm working on climate litigation and private sector. And I think what Andreas is doing is super interesting for what's going to come in the years that we have ahead of us. We know that we have a climate emergency, and this is something that is happening, and we're dealing with it. At the same time, we have an energy emergency, and what we're seeing is that we might need to find new ways, new tools to create compliance, to create change. One of those could be perhaps this issue of extended liability, of litigating. We know there are some cases out there already. You might have heard of a case against countries, for example, Urgenda case, that's in the Netherlands. I don't know if some of you are familiar with this one. Supreme Court case, more for us locally here in Norway, and I see that there's quite a few of you guys that are Norwegians. Paragraph 112 of the Constitution, also in Norwegian known as Milieudefensie, very important. Now this is being sent to the European Courts of Human Rights in Strasbourg. There's going to be a new round of litigation. These are cases against the state. But Andreas is going to talk to us a little bit about a different thing. He's going to speak to us about private sector litigation. One very clear example of this is the Shell case. I don't know if you have heard about it. This is this case against an oil and gas company in the Netherlands, where the court in the Netherlands understood that there could be a breach of the civil code of the Netherlands, along also with international law, by this oil and gas company connected to climate because of all the emissions that they are polluting. So with that being said, I wanted to extend my gratitude to Andreas for coming all the way from Oslo and being here with us today. We're going to have his presentation, and Andreas, you will have about half an hour, 35 minutes, and then we will have a session of questions and answers, which Envido, the other co-organizer of this event. Thank you so much, Tusen Takk, for being here and putting together this activity. You will be coordinating and having a dialogue. And for those of you online, and for those of you here, we really want you to raise your questions. Andreas is not shy, so he's happy to take them on board. And I'm not shy either, so if you don't ask anything, then I'll make sure I'll ask the not very nice questions. I'm like, Andreas, this doesn't make any sense. Can you explain this to me? I'm very old-fashioned. No, but jokes aside, thank you so much, Andreas. The floor is all yours. Let's see if the mic is working.
Let's see if it's working.
Is it working? Yes. And online, do you hear Andreas as well? If you can, someone say something on the chat. Andreas, can you say something?
Can you hear me at home?
Don't want to say anything.
Yeah, we hear you. Thank you.
Okay, that means that it is working. So, Andreas, thank you so much. The floor is all yours. We look forward to hearing you. I'll give you a sign when you have about 5 minutes left.
Yeah.
But you're Swiss. I'm not concerned about timekeeping.
No, exactly.
Well, thank you so much for being with us.
Well, I have lived in Scandinavia for 2 years, so but you're also quite good with time. But very good. Thank you so much, Ignacio, for the very, very kind introduction, and also obviously thank you to Enviro for also setting up the event. I'm extremely honored to be here. Really appreciate it. Don't take it for granted. You could be doing anything, but you're here or online. I appreciate that a lot. I'm looking forward to mostly your feedback and your discussions and your questions and comments I'm sure you'll have. As Ignacio said, I will be speaking on this new topic of climate litigation, specifically against private actors. So that's a bit less well known than litigation against states. And I'll speak about the reasons why that is. Yeah, we ready? I'm going to do a little survey before we start. Who of you, just to get to know you a bit better, who of you has heard the first time today of climate change litigation? Exactly, Ignacio, and someone in the back as well. Who has the opposite dealt in depth with this specific topic of climate change litigation against private actors? We have some experts. Okay, we have at least one expert in the room. Good. So the others, I assume, are just generally interested in the topic, which is also very good. Oh no, that's the wrong laptop. So let us start with this, if it's working. I'm actually gonna start with a short video. Oh,
boss.
Without that,
The new intensity.
click that away.
Global warming, or none like it hot. You're probably wondering why your ice cream went away. Well, Susie, the culprit isn't foreigners, it's global warming.
Global warming?
Yeah. Meet Mr. Sunbeam. He comes all the way from the sun to visit Earth.
Hello, Earth. Just popping in to brighten your day. La 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 la. And now I'll be on my way.
Not so fast, Sunbeam. We're greenhouse gases. You ain't going nowhere.
Oh, oh, God, it hurts.
Pretty soon, Earth is chock full of sunbeams. They're rotting corpses heating our atmosphere.
How do we get rid of the greenhouse gases?
Fortunately, our handsomest politicians came up with a cheap, last-minute way to combat global warming. Ever since 2063, we simply drop a giant ice cube into the ocean every now and then.
Just like Daddy puts in his drink every morning. And then he gets mad.
Of course, since the greenhouse gases are still building up, it takes more and more ice each time. Thus solving the problem once and for all. Once and for all!
There we go. So that's just to warm you up, to assure you there's nothing to worry about. Okay. What I'm trying to do is to do a little shift of thinking away from the way most of climate, what's called global climate governance has been done in the last 30 years, which is at the international level under the UNFCCC. And that means we're talking about the intergovernmental level. So states come together and they somehow solve this issue, and it's 30 years ago. As many of you know, there was the UNFCCC was adopted in 1992, then we had the Kyoto Protocol, and the last cornerstone that most of you will well know is the Paris Agreement in already 7 years ago. And this year we'll have COP27 in Egypt, brought to you by a beverage company, which speaks to itself a bit in my view. So what we have is an exclusive focus on the rights and obligations of nation states. How's that going? Well, not so well, arguably. So the last 30 years, when we had this framework under the UNFCCC, emissions have continued to rise, and also since the adoption of the Paris Agreement. So the heat is on, as this report by UNEP, which is the emissions gap report, the last one from 2021, put it that way. So it's not really working well, at least if you say working well means actually reducing emissions. We have two statements here. One is from the UNFCCC Secretariat, which said the NDCs, which are the nationally determined contributions of the states under the Paris Agreement, taken together fall short of what would be required to achieve the temperature goal of the Paris Agreement, which is, as you well know, well below 2 degrees or 1.5 degrees temperature rise. And the second being, even if whatever governments currently say through their NDCs, even if they do that, the best case scenario would lead to an estimated 2.7 degree increase of global warming by the end of the century, which is much more than the international community has agreed to or want to achieve. So it's a fair question to ask, are we actually on the wrong path by looking only at states? Again. So the shift in focus is this one. And this is research by Richard Heath, a professor from the University of Colorado. He published with his team in 2014 this carbon matrix report. And if you look at this report, you will find one very interesting graph, which is the one you see here on the left. You have a black and a red line. The black one is all global CO2 and methane, CH4 is methane, emissions in the world globally. And the red line is all the same emissions from so-called carbon majors. Who are these carbon majors? We'll talk about that in a minute, but it shows you that the bulk of all industrial greenhouse gas emissions can be attributed by looking at historical data, which is publicly available, to a number of under 100 corporate entities, so producing entities, which is very important. The international law on climate change looks at states as sort of consumers of products. And this is another focus. You look at the producing side. And there, obviously, states themselves don't produce much emissions by themselves, but it's actually corporate entities. And it gets a bit more complicated than that. As you in Norway well know, the lines between private and state, especially energy sector, aren't always so clear. Many companies in the energy sector are actually state-owned or state-controlled, and others are not. So pick your favorite here. Actually, the biggest ones are state-owned entities, and but there you have also some very, very significant private companies, such as those listed here, and we'll come back to number 6 in a few minutes, which is Shell in the Netherlands. So one step back, how are corporations looked at in international law? They are so-called non-state actors, which is the accepted view. Despite efforts since the 1970s to actually impose obligations on non-state actors, mostly driven by the United Nations, that these efforts have failed. So the result is that today, by and large, these companies are operating outside of the reach of international law. And that's also the case in climate change law, which is somehow logic if you look 50 years back. But is it still the adequate legal framework today? That's a question mark. So at the end of the day, for us, the question comes up, do MNEs, what is that? Multinational enterprises, that's OECD language for big transnational companies. Do they actually operate in a legal vacuum in the climate change space? Well, I would argue, and so do many others, not quite. When I started thinking about this some 2 or 3 years ago, I thought, okay, that's a legal question, but it's also not only a legal question. This term of corporate climate responsibility that I came up with my colleague Professor Weber. We published a paper on that, and we tried to put it all together in this one graph, where we said, okay, corporate climate responsibility, what is that? How is it influenced? So on top, you have the international legal framework, which, as we saw before, is not directly relevant for, at least for private companies. But very importantly, on the right, you have market forces. So institutional investors and other mainstream investors are more and more interested in how to handle climate risks, because they have, at least in theory, a long-term focus. So they're looking at saving your pensions, or making sure you actually get some money in 30, 40 years. So they have a long-time investment focus. On the bottom, you have broad and responsibility concepts. I will not go into detail about that. That is more an academic debate, very fundamental about what is the purpose of the company, what's the social contract, that what is the role of corporations in this society. And today I'll be only speaking about this interesting left corner, which is litigation. So actually going to court and asking a judge to actually order a company to do something or to stop doing something. Okay, let's go a bit into detail. There is no generally accepted definition of climate change litigation, and also not one for private climate change litigation. So I came up with this one here, which is being published next year. So I view it as legal actions brought before judicial or non-judicial dispute resolution bodies. So there's not only courts, you also have some other avenues that you can choose, such as OECD contact points, that have a reasonably clear link to climate change, meaning climate change is not just some small aspect of the case, but actually the core issue. They are directed against a private actor, and they have their legal basis in private law. And we'll have some examples later to see what I actually mean by that. Where does this, today it's a trend, but where did it come from? From the US, as so many things do. We had some cases more than 10 years ago in the US, and mainly against huge energy companies such as ExxonMobil. More recently, we also see huge cases in, as Ignacio mentioned, in European countries, continental Europe for the most part, but also Australia, interestingly. And today, they're not very good numbers, but a rough estimate based on the Sabin Center's litigation database, which is leading in this field, is, I would say, 100 to 200 cases worldwide, all against private actors, and total of all cases, meaning all cases against governments and companies together, is about 2,000 worldwide, and that is a strongly rising number. Let's take one step back again. What is actually, why would you file, why on earth would you file a lawsuit against a private actor about climate change? I mean, you could say it's a global collective problem. We have all caused it. We still contribute to it, some more, some less. So why do you single out one actor and sue him in court? So there are generally three main reasons why that is done. I think one is backward looking, based on the fact that collectively and in some cases individually, corporations have, through their emissions, significantly contributed to climate change. And in some cases, those emissions rival the emissions of entire states. And also, it is well documented that some of these carbon majors have been actively casting doubts about climate change, despite knowing internally better. Then the other one is forward-looking. The business sector is obviously essential in the net zero transition. So the goal is to have net zero emissions by 2050 and like halving emissions until 2030, which is very soon. So it's a huge shift in all sectors. And the business sector is obviously central to that. And the third is the present. What is the status quo? We are confronted with a significant amount of discourses of delay, also by states and by companies. Yes, also individuals, meaning that the saying is something like, yes, someone will do something at some point in the future, but not us today. There's deep faith in technology and markets to somehow solve climate change, which you will find also in the famous Stern report of 2007, if you're interested in that. And you obviously also have a quite significant amount of greenwashing and lobbying going on. I have come up with two categories of cases of private climate litigation. One is a bit better known, that is what I call David versus Goliath cases. For example, the Shell case that was mentioned by Ignacio, that I'll go a bit into detail after. That means this kind of well-known case, individual or NGOs against multinational energy or finance or manufacturing or what have you company, transport. There, the typical argument is historical responsibility. So saying you have misbehaved in the past, so we're going to make you pay for the damages you have caused. That's the argument. And the typical legal basis there would be in tort law, which you have in all countries, or a civil law equivalent to it. And very interestingly, a very recent development has been that you, in those countries where that is possible, and you're not left out of the courtroom for doing it, indirectly apply human rights, international climate change law, and so-called RBC standards. So these are responsible business conduct standards. The most importantly, the UN guiding principles and the OECD guidelines for multinational enterprises. Not very well known, but I can tell you they're very interesting to look at. So these are not applying directly to companies, but you can interpret tort law. You take a source in tort law, and then you apply international law, and you interpret a norm in tort law. Sounds complicated, but I'll get back to a concrete example right after. The typical remedies, or what you're asking for, is typically money or declaratory relief. So you just want to have the court declare that there has been a damage and that this has been unjust. Or, and that is very interesting, an injunction, actually asking the court to impose an order on a company to do something or to stop doing something. So it's not about money, but to change the behavior, which is very unusual in this context. On the other hand, that's actually my focus. The right side of my PhD is corporate law. Not so well known, but there are actually in corporate law and in the financial markets many climate change cases coming up. These are a bit more complicated to explain. I go through it very shortly. These are brought by shareholders, so not NGOs or individuals, but typically shareholders, and they have a financial interest. So they are saying, you company, you board of this company, you aren't managing your climate risks very well, and you're also not disclosing climate risks, notably financial risks. Climate change causes financial risks today, and therefore we sue you, and first of all change that, or second of all pay us compensation for that, because you have through that caused the damage. Our shares are worth less now. So that is based on corporate law or securities law. These two types of cases are very different, but it gives you a bit of an overview of what I'm actually talking about. Let's go to a concrete case, which is, in my view, very interesting case in the Netherlands, Milieudefensie against Shell. Here you see some of the key figures in that case. What was that case? Who knows this case? Who has heard of this case? There are a few, yeah, okay. But not very well known, okay, good. Who is Shell? Going back to this figures, according to the research I have shown you, carbon major number 6, so globally the 6th highest industrial emitter historically. And this case was brought in 2019 and decided by the District Court of The Hague. So the court of first instance in May 21. And it was actually groundbreaking because it was the first time worldwide that the court directly ordered a company to reduce its emissions, and not just a bit, but as you can see, by at least 45% until 2030. And why is that? That is because of climate science, because that is the emissions reductions trajectory that, according to climate science, needs to be done to keep a fair chance of keeping the world at 1.5 degree temperature increase in line with the Paris Agreement. So it's unbelievable that this judgment was made, and obviously is on appeal. And importantly, as you can read here, that order encompasses all of the group companies. So you can imagine Shell's a huge worldwide group, and the order was given to the top holding company, which is in the Netherlands. But the reduction order is to reduce all of the group's emissions, so more than 1,000 subsidiaries worldwide, and also very importantly, encompassing all direct and indirect emissions. So we make a distinction between scope 1 through 3. That's very important in the energy context, especially scope 3, meaning those emissions that occur when producers, you and me, use energy products sold by Shell. You will have you. So it's very notable that the court tells the company you have a responsibility for that because you produce these products. So this is an obligation of result. The court just told the company you have to achieve this. However you get there, that's up to you. And the court also said this order is immediately enforceable, so you need to start doing that now. What was the legal basis for that? As Ignacio briefly mentioned, interestingly, a very broadly framed provision in Dutch tort law, which you will find in many jurisdictions in a similar form. And specifically, the one variant highlighted yellow here was applied. So an act or omission in violation of duty imposed by law, not our case, but our case is the following: what according to unwritten law has to be regarded as proper social conduct. What does that mean? That is obviously subject to interpretation. How did the court make this interpretation? Well, drawing on a number of factors and facts, legal and non-legal aspects were taken into consideration. First of all, the physical impacts on the Netherlands and specifically the Wadden Sea region, so the, I understand correctly, the most low-lying area of the Netherlands, which is very beautiful, by the way. Importantly, human rights were used, as that's what I was trying to say indirectly. So you cannot apply human rights directly to a company today, but if you take a standard in tort law, you can then use human rights and interpret the standard in line with these human rights, which was happened here. And also these international RBC standards that I mentioned were very important in this decision, the UN Guiding Principles and the OECD multinational guidelines, they're both from 2011. The court further discussed the responsibility for scope 3 emissions. Drawing on these RBC standards, the court said, you company actually have a responsibility for indirect emissions because you determine the energy package. So the argument is you can decide, do you invest in oil and gas or fossil fuels, or do you invest in something else? And that way you shift the energy package. And because you have that power, you are actually responsible for what comes out of that at the end, which is the end consumer emission. Also, that the parent company had control and influence over the group's emissions, because as you can imagine, the top company sets the policies and also reports on whatever is going on in the entire group. We have emission trading schemes. I am not going into detail with that, but happy to discuss after if you want. And the court was drawing on the IPCC's reduction pathway as set out in the special report of 2018 of the IPCC, and it discussed the market substitution argument, which is of course a very strong defense. The company can say, yeah, whatever we do, it doesn't matter. The market will just replace us. Our competitor, if we don't do it, someone else will do it. Big question if that is a legal argument or not. Anyway, it came to the order I showed you before, but these were the considerations that were made, and they're for sure playing a big role in the course of the remaining proceedings. So this having been a very key case to follow, let's go a bit more to the general level again. What are main obstacles if you take the perspective of plaintiff in such a case? What are your main legal problems? Obviously, in every legal case, there are many obstacles, but here they are even bigger, I would say. But obviously standing, so are you actually allowed to bring a lawsuit? Can you do that? It depends on the country where you bring the legal claim. Can be very different. There are problems with cost, obviously, because you can be an NGO or a small shareholder, doesn't have much money, can even maybe not even afford a lawyer. On the other side, you have a huge multinational company who that is not a problem, who may have even an insurance to cover these costs. These proceedings are very lengthy, which is a problem. Look, if you look at the need to reduce emissions by 45% until 2030. I mean, if you start a proceeding today, that may easily take until 2030. So that's a problem. And then the burden of proof. And these are more the procedural problems. Then you also have some substantive legal problems, of course, with causality, which was, by the way, not an issue in Shell because it was not about compensation. So Shell was not about money, but it was about changing behavior. You need to prove a harm, usually. And also, there's not so much discussed in literature, as far as I read, statute of limitation. So some of these acts occurred 100 years ago. Are you still liable for that today? Probably not, or I don't know. You can. It's debatable, and cultural differences between countries. So the Netherlands may be, as you see, more susceptible to these kind of arguments, progressive, if you will. And in other countries, let's say Switzerland, Norway, I don't know, you would arguably have a harder time, even harder. Okay, what's the outlook? Do we see a wave of lawsuits? I don't think so. But clearly the liability risks are clearly rising. Questions will be, does your jurisdiction allow mass claims? Some do, some do not. In the Netherlands, it's possible. What about insurance? There's an important topic is directors and officers insurance. So if you are a director of a company, you can actually, or usually have an insurance against these types of liability claims. Process financing, can you as an NGO or a small shareholder, are there ways you can, does your country allow that you have a third party fund your litigation? Big question. There are almost no precedents, but you can draw certain conclusions or speculations from tobacco and asbestos litigation, if you have ever heard about that. It's very interesting to look at. And there's so many developments. The judgment I'm waiting for most at the moment is by the European Court of Human Rights on the climate change cases, notably against states. Don't have time to talk about that, but something different, litigation against a state or private company, but they're also influencing each other very much. That is already almost it. My main takeaways for you are, I would say, to be aware that there's a clearly growing trend of private climate litigation. Liability risks, in my view, are growing, including because plaintiffs are increasingly sophisticated and now also successful. Exclusion the US. This was told last week by colleagues from the US. It's not really going anywhere, although they had it for 20 years, but it's extremely not looking very promising from the side of plaintiffs in the US. In Europe, it looks different. So stay tuned. If you want to connect with me, the best way is probably LinkedIn, so you can follow what I'm doing and I can follow what you're doing. Or email me, and I also created a little website with 3 climate law colleagues in Switzerland. For now, it's mostly German, but have a look if you want. Part of it is English, so no Norwegian section so far, but hopefully soon. Fusion Talk, thank you so much for your attention and looking forward to the discussion.
All right, thank you so much, Andreas. This was very interesting and very clearly explained on these different issues. So we're going to stop sharing the screen for a minute here, and we will keep the slides here on the side. What we're going to do is we're going to stop the recording so that we can have a free conversation and people can voice their opinions. So just give me a second. I'll stop the recording now.